is up, Truth and Transparency? Good to be here. This case is literally a train wreck, car crash that you cannot stop watching. Again, that is just my take on it. Welcome back to Truth and Transparency. Thank you, members, subscribers, moderators. A little bit of happy hour here. I will be live later this evening, recapping the interview and discussing the interviewee that I had on last night for the Idaho 4 case. Chuck was awesome. Chuck is awesome. Shout outs to him and his girlfriend. So that'll be a little bit later, a nightcap recap. So we have Morgan Wallen in the house. He is at Ohio Stadium right now. He is getting prepped for his double banger of a weekend. Morgan Wallen will be live from the Ohio State, The Shoe, playing tonight and then tomorrow night. Who knows? Maybe I can snag an interview and ask him about how that all went down with being able to provide Ethan's family with a great experience. But yeah, Morgan Wallen's in town. Pour me. Pour me another round. Exactly. Pour me another round. I'm going to crack open up a Modelo because what we're about to take a look at here is the first and ever court appearance of Karen Reed. Karen is definitely not a Karen. Karen's not, she's definitely not a Karen in my opinion. But let's take a look at Karen's first court appearance, and then I'm going to show some stuff that I showed earlier with Turtle Boy and breaking down the digitals and how in the world is this even in court? If I lived in Massachusetts, if I lived in this little Canton, Massachusetts town, I'd be one pissed bitch that my tax dollars were going to this. So, what's up, Mandy? What's up, Ms. Potts? You guys, if you think Brian Kober is getting the shaft, whew, it ain't nothing compared to what's happening to Karen Reed, and she's getting the shaft from the Boston Police Department. Her boyfriend and her went out, hung out on January 29th, went bar hopping like normal people do. They then get invited to go back to a house party at one of the police officers' house. They were throwing a party. There was multiple people there. Karen didn't really want to go because she didn't know anybody. So she just dropped off her boyfriend. And that's where everything went south. She drops him off a little bit after 12. And then we're going to get into this, but what transpires, or what the courts and the police and the prosecution is saying transpired, is fucking crazy. And yeah, so let's break it down. Here we go. Pull me. It's a sad case indeed, because I think people are missing the fact that, dude, John O'Keefe lost his life. Like, nobody is talking about, I feel like everything's like on Karen, but it kind of needs to be, because she's about to lose her life if this completely goes and continues to go this way. But this is wild, guys. This is absolutely wild. So a lot of you guys have been asking for this. So cheers to you, because you got your wish. You got Lana deep diving over here. Let's check it out. Let's check it out.
Leaving the scene of personal injury and death. These offenses taking place January 29, 2022 in the town of Canton.
Good morning, ma'am. I'm advising you pursuant to Mass General Laws, Chapter 276, Section 58. Should you be charged with a crime or violate a release condition while this case is pending, you could be held in the House of Correction for up to 90 days without bail. Good morning, Mr. Netti. Good morning, Mr. Lely.
Good morning, ma'am.
All right. Mr. Lely.
Your Honor, with the court commission, could I just pull the mask?
Yes. Yes.
Thank you, Your Honor. Your Honor, Adam Lally for the Commonwealth. The Commonwealth is requesting that the court set a cash bail in this matter in the amount of $50,000 with some additional conditions. Those conditions being the bail warnings as just read by Your Honor to the defendant, as well as conditions that she stay away and have no contact with the deceased victim's family, that she stay away and have no contact with the deceased victim's residence, and that she be prohibited from operating a motor vehicle during the pendency of this case. In support of that request, Your Honor, the Commonwealth would cite the nature and circumstances of the offense, as well as the potential penalty that the defendant faces, particularly with reference to the manslaughter charge and the leaving the scene of personal injury and death, the latter being a bind over. The facts of this case, Your Honor, essentially on Friday, this past Friday into Saturday, January 29th, at approximately 6:04 a.m., the Canton Police Department received a 911 call from a woman reporting a male party subsequently identified as the decedent and victim, Mr. John O'Keefe, who was found in the snow at a residence on Fairview Road. At the time of the 911 call, there was heavy snow and the temperature was in the teens. Officers Saraf and Mullaney of the Canton Police were dispatched to the scene along with Canton Fire and EMS. Officer Saraf was the first to arrive on scene and observed 3 females waving at him. If you were standing on the roadway looking at the property, the 3 females were in the left corner of that property. Officer Saraf observed the victim lying on the ground as 2 of the females were performing CPR. The 3 females on scene were subsequently identified as the defendant before you, Ms. Karen Reed, Ms. Jennifer McCabe, and Ms. Kerry Roberts. Officer Saraf observed the victim to be cold to the touch, no signs of breath, and returned to his cruiser to retrieve his AED device. At this time, Canton Fire and EMS arrived on scene.
This is the probable cause.
Aid. Paramedics then transported the victim to the Good Samaritan Hospital in Brockton, where he was determined to be deceased several hours later. Several detectives from the Canton Police arrived on scene moments after the 911 call. They began to search within the snowbanks for any evidence, at which point they discovered a broken cocktail-style glass and multiple patches of red substance that appeared to be blood in the vicinity. They secured the glass and 6 blood samples from that area as evidence. Troopers from the Norfolk County District Attorney's Office.
They secured these samples in red Solo cups. What? What? Stop, Lana. You're kidding me, right? No. Oh, no. I was just told red Solo cups, 6 of them.
Specifically,
Conveniently
Sergeant
left out of the
Mechanic
PCA.
and Skipper Proctor then arrived at the scene, began the process. They also spoke to several witnesses. Specifically, they spoke to Ms. Jennifer McCabe. She stated that the evening prior, she and some friends were at the Waterfall Bar located within the town of Canton. She stated she and her husband arrived there at approximately 9 p.m. At approximately 11 p.m., the victim and the defendant arrived at the Waterfall Bar together. She indicated to the troopers that the victim and the defendant had been in a dating relationship for the last 2 years, and that the defendant often stayed at the victim's house most nights, is what she described it as. She observed the defendant walk into the bar holding a glass cup from C.F. McCarthy's, which is a bar located across the street from the Waterfall, with a clear liquid inside and what she believed to be a vodka soda drink. She observed the victim to be wearing a baseball hat, jeans, and sneakers. The victim and defendant had been at C.F. McCarthy's across the street before coming to the Waterfall Bar, as I stated. She stated that the victim and defendant appeared to be in a good mood, did not observe any arguing amongst the two, described the atmosphere within the bar as friendly amongst the patrons. She indicated as the bar began to close down, everyone was invited back to that residence on Fairview Road. She observed the defendant and the victim leave the Waterfall Bar together. As the group was exiting, the victim texted Ms. McCabe, where to, at 12:14 a.m.
So 12:14 a.m. Where to? That's what the victim, John O'Keefe, texted. So something to be noting here is that to be able to see people leave, meaning Jennifer McCabe, to be able to see the victim and Karen leaving, is that you're still there. You know what I mean? So again, she said that they were not arguing, anything like that.
She replied with the address on Fairview Road at 12:18, 4 minutes later.
So then 12:18, she gave the address of where this party was. You know, where to. And so 12:18, going back to the house party.
The victim called her to ask where specifically the house was located on Fairview Road. While inside the residence,
So then the victim called her, meaning Jennifer called to ask where was the house actually located. Let's see.
she observed a black SUV arrive in front of the residence on Fairview Road. She observed this from the front door. She texted the victim at 12:31 a.m., hello, and at 12:40 a.m. texted, pull up behind me. She then observed the black SUV move from the initial place the vehicle stopped on the street near the driveway and then proceeds to the left side of the property. At 12:45 a.m., she texted the victim hello again and then observed the black SUV drive away. She stated that they discovered the victim in the area where she last observed the SUV on the left side of the property as facing from the street. And at approximately 4:53 a.m., she received a phone call from the defendant looking for the victim. She indicated that the defendant was distraught and drove to her house. The defendant indicated to Ms. McCabe that she last remembered seeing the victim at the Waterfall Bar. Ms. McCabe then informed the defendant that she observed the victim and her leave the bar together. Ms. McCabe then drove the defendant's vehicle from her house back to the victim's because the defendant was too hysterical to drive and had the other friend, Ms. Carrie Roberts, follow them. While driving to the victim's house, the defendant stated to Ms. McCabe, could I have hit him? Did I hit him? Ms. McCabe stated that the defendant told her about a cracked taillight on her vehicle. Once they arrived at the victim's home, the defendant had Ms. McCabe looked at that same cracked taillight. Ms. McCabe described the passenger side right rear taillight as cracked. They then both entered Ms. Roberts' vehicle to look for the victim, with the defendant seated in the back as Ms. Roberts drove and Ms. McCabe was seated in the front passenger seat. Ms. McCabe stated that they turned on a Fairview Road from Chapman Street. At the time, it was snowing heavily, creating poor visibility. Ms. McCabe stated that just prior to the residence on Fairview Road, there was a cluster of trees, and immediately the defendant stated that she saw the victim. Ms. McCabe and Ms. Roberts were not able to see the victim and were initially confused by the defendant's statement. Ms. McCabe stated that Ms. Roberts began wiping snow off of the victim as the defendant laid on top of him for warmth and then began CPR. The troopers then proceeded to the Good Samaritan Hospital to view the victim. They observed approximately 6 bloodied lacerations varying in length on his right arm, the cuts extending from his forearm to his bicep. Both of the victim's eyes were swollen shut and black and blue. They observed a cut to the right eyelid area of the victim. Observed his clothing to be blue jeans, an orange t-shirt, a long sleeve shirt, and boxer shorts that were saturated with blood and vomit. They observed one black Nike sneaker with a white Nike logo on the sides belonging to the victim. On the 31st, the troopers attended the autopsy of Mr. O'Keefe at the Office of the Chief Medical Examiner. The doctor performed the autopsy. Dr. Scorty below advised of several abrasions to the right forearm, 2 swollen black eyes, a small cut above the right eye, a cut to the left side of his nose, approximately 2-inch laceration to the back of his head, multiple skull fractures that resulted in bleeding, and further advised that the victim's pancreas was a dark red color, indicating that hypothermia was a contributing factor to his death. On January 29th, the troopers conducted several other interviews, including Ms. Roberts. During the course of Ms. Roberts' interview, she indicated that she was initially contacted by the defendant, Ms. Reed, at 5 a.m., that she answered the phone to hear the defendant state, John's dead. Terry, I wonder if he's dead. It's snowing. He got hit by a plow. The troopers also on the 29th proceeded to the defendant's parents' home in Dighton, Massachusetts, where they located the involved vehicle, which is at 5 a.m. That she answered the phone to hear the defendant state, John's dead. Terry, I wonder if he's dead. It's snowing. He got hit by a plow. The troopers also on the 29th proceeded to the defendant's parents' home in Dighton, Massachusetts, where they located the involved vehicle, which is a 2021 black Lexus SUV. That vehicle was ultimately seized and taken back to the Canton Police Department, where it was processed by various factions of the state police. Their observations of that black SUV indicated a crack in the right rear taillight. They did speak with the defendant. She indicated that she had met with the victim at the C.F. McCarthy's bar in Canton at approximately 9 p.m. on the 29th, that he was there with several friends prior to her arrival. She stated the victim was consuming beer and she was drinking vodka sodas. She described the glassware she was drinking out of as a vase style. She stated she and the victim left C.F. McCarthy's and went to the waterfall. That she did not. She indicated to the troopers that she did not leave C.F. McCarthy's or enter the waterfall bar with a glass or drink. She stated that she and the victim were at the waterfall for approximately 1 hour. During that time, there were no altercations and no injuries, no cuts or abrasions that occurred with the victim. She indicated that they left the waterfall and were invited to the house on Fairview Road. She stated that she dropped the victim at the house on Fairview and went home since she was having stomach issues at the previous bar. She stated that she dropped the victim off. She made a 3-point turn in the street and left. Did not see the victim enter the house. She indicated that she first observed the broken taillight in the morning and did not know how she broke it the previous evening. She indicated that house on Fairview Road. She stated that she dropped the victim at the house on Fairview and went home since she was having stomach issues at the previous bar. She stated that she dropped the victim off. She made a 3-point turn in the street and left. Did not see the victim enter the house. She indicated that she first observed the broken taillight in the morning and did not know how she broke it the previous evening. She indicated that she discovered the victim in the morning. She observed him lying face up, snow on his legs, eyes swollen, and blood coming from his nose and mouth, and that she provided mouth-to-mouth upon her arrival. Further indicated that throughout the night she had been calling and texting the victim numerous times with no response. Officers also interviewed several first responders, including a firefighter paramedic from the town of Canton. Indicated that she arrived on scene, observed the victim's condition, went to speak to the defendant in regard to any sort of prior medical issues or causality of the injuries that she observed to his face, to which the defendant then made several statements to her, indicating, "I hit him, I hit him, I hit him, I hit him." As I mentioned, the black Lexus SUV was seized. There were fragments of broken glass that were observed on the rear bump of the vehicle. The rear right passenger side taillight was shattered, pieces missing from the red and clear areas. On the right side of the rear tailgate, a deep scratch and minor dent was observed. On the right side of the rear bumper, above a small red light, 2 scratches were observed in one area where paint was chipped off. Troopers from the collision analysis and reconstruction section of the state police performed several tests on the vehicle, including a rapid acceleration forward and reverse, noting that there was no deficiencies with the braking system. They also implemented the use of a training figure resembling a human approximately 6 feet in height that was placed behind this Lexus. It was operated by members of the cars unit and documented with video. The vehicle was placed in reverse and started to travel towards said training figure. The rear view camera on the vehicle was operating properly, providing a 180-degree visual. And as the Lexus traveled closer to the figure, both auditory and visual cues began to sound off within the vehicle, indicating an obstruction to the rear. In addition, on the 29th, the Massachusetts Special Emergency Response Team, or CERT, was activated to assist in searching for potential evidence outside of the residence. Standing on the street, looking to the left of the property, there was a fire hydrant located there. In that area, they located a black Nike sneaker with a white Nike logo along the side, matching that found on the victim's body. In the area of the street where the victim was recovered. In addition, in that same area, they located 2 red plastic pieces of a taillight consistent with the missing pieces from Miss Reed's black Lexus SUV, as well as 1 piece of clear plastic piece of a taillight located in the same area, also consistent with the broken taillight on the Lexus SUV. Your Honor, with the nature and circumstances of those facts, as well as the potential penalty the defendant faces on these charges, the Commonwealth is requesting that the court set a $50,000 cash bail with the conditions as outlined previously.
Thank you, Mr. Lally.
Thank you.
Mr. Yannetti, and if you would, go right to the mic.
Thank you, Your Honor. Good morning again, Your Honor. David Yannetti for Karen Reed. Judge, my client is 41 years old with no criminal record. My client grew up in Taunton, Massachusetts. She's a graduate of Coyle Cassidy High School in 1998. And when it came time to go to college, she stayed in Massachusetts and went to Bentley College. She graduated with a Bachelor of Science in Finance in 2003. And since then has worked in the financial sector. And in fact, she's been at a very large, well-known financial company since 2000.
Holy crap. I mean, what type of a judge, what type of a DA, what type of a human being could literally look at this vehicle, this Lexus, and see that there's just, oh my God, this little nick of a taillight being nicked out. And even if you're, I don't know, you had a scratch or two, how in the world would that ever be consistent with the injuries on this male body? This case implicates, when you're talking about a cover up, when you're talking about a frame job, you're talking about multiple people that have to be involved in order for this to be a frame job, which I do believe it is. Let's just throw that out there. But we're starting back from the beginning. You hear this and you're just like, well, that's not how any of these injuries occurred. So even if she would have, I don't know, hit him, let's say, or if a plow hit him, none of that is consistent with his injuries. I mean, anybody can see that. So like, how are you possibly going to say that any of this happened? Like, this is just wild that this DA literally got up in front of a judge and is reading this report to me, because I don't know who's worse right now, the people that did this to John O'Keefe or this man, in my opinion. Because this man's sober doing this, okay? Let's just say that the people that would have been at this party, they're fucking hammered, right? Doing their stupid shit. This is a sober DA reading this with a straight face. Like, who the fuck is going to believe this? What jury is going to believe this? Like, meaning this, take Karen Reed out of it, take John out of it. You have a body, these are the injuries, and you're going to sit here and say that she backed up and hit him one time? Would she keep doing this with her car, going back and forth? Like, and then like what, placing him like, oh wait, let me cut you, like, what? Like, this is unbelievable. Because like, take out the people. Here's the body, here's the injuries. Vomit and blood on him, on his boxers and stuff. Like, oh, we're gonna break this all the way down because this is sick to me. So like I said, you think Brian Koberger is getting nice?
2007, where she's currently an equity analyst. In addition, she's an adjunct professor at a Massachusetts university as well, and she's been there since 2008. In addition, Judge, my client suffers from a host of medical issues. From the time that she was 25, she's had multiple serious illnesses diagnosed, beginning in 2005 with colitis, which ultimately led to her colon being completely removed in 2009. She's been in pain for a number of years, and eventually also was diagnosed with MS as well in 2013. Continued to have digestion issues and bowel issues. And this past summer, my client unfortunately was diagnosed with having a brain tumor as a result of migraines that she had never had before. There is still no answer regarding whether that brain tumor is cancerous or not. And I bring this up not for the purpose of evoking any sympathy, but to focus on what the court's inquiry is here today. The inquiry is, what is the likelihood that my client will appear in court for her trial? Does bail need to be set to assure her appearance at trial? And if so, how much bail should be set? Her roots are here. She was born here, she went to school here, she went to college here, and her doctors are here. And in addition, her family is here. Her parents are present in the courtroom, her brother and her sister-in-law are present in the courtroom. And Your Honor, just so the court's aware, I'd like to have a letter that I sent to the Norfolk County District Attorney's Office this weekend. It was faxed on Saturday, where I promised that my client would appear if they just called me. All they had to do was notify me, and I wrote right in the letter that she would report to any police barracks or police station or courthouse to which they directed me. They ignored that and instead got an arrest warrant for my client. However, she knew. She had hired an attorney since January 30th, this Saturday, because the police had come and they had taken her phone and they had taken her car. She knew that they were considering her a suspect, rightly or wrongly. And what did she do? They arrested her at the very address that I included in my letter to the Commonwealth, which the Commonwealth ignored. This is relevant, I would assert, Judge, regarding whether she is a flight risk. I think that it doesn't really pass the straight face test. She is not going anywhere. She didn't go anywhere. I frankly don't think they've overcome the presumption of personal recognizance in this case. With regard to the facts of the case, Judge, I've read the affidavit that the prosecution has now read. Manslaughter is a tremendous reach in this case. I don't see any criminal intent that would justify manslaughter in that affidavit. And there's a reason for that, because there was no criminal intent. This was not some random stranger. This was my client's boyfriend, somebody with whom she was in love, somebody with whom she essentially lived with. And by the way, the police have her phone. At 4:30 in the morning, my client is placing multiple calls to the victim in this case, to her boyfriend, wondering where he is, why he hasn't come home, and getting annoyed with him because his niece, of whom he was a guardian, had to go to bed without saying goodnight to him. She had no idea that he was deceased or that anything had happened. At 5:30 in the morning, she's placing probably about 10 calls to him for the same reason, before she now knows something's has to be wrong, because he never stayed out at night without her. If they were ever out at night, they were always together. He had never not come home. And that's when she calls her girlfriend and goes back to the scene and sees this horrific scene. So, Your Honor, this is a defensible case. There is no reason for her to run. She's done the opposite. She hired an attorney almost right away. And by the way, there will be substantial issues regarding a motion to suppress statements here. As I put in the letter, and I'd like to, again, have this marked as an exhibit for the bail hearing. As I put in the letter, the police multiple times violated her.
Mr. Lally, any objection to the letter?
No objection.
All right, thank you. We'll accept it. We'll mark it.
Thank you very much.
Go ahead.
Yeah, the police violated her right to counsel multiple times, Your Honor, and we'll be able to show that at a motion to suppress hearing. Their case essentially comes down to statements,
This
because
is like just
there's
like
no
Dr. Miller.
eyewitnesses. There doesn't appear as though there's any video evidence. There's nothing to indicate what actually happened on the day in question. And I think the police sort of acting out of desperation, realizing that they didn't really have much of a case, needed some type of confession from her. She did not give it to them, and yet they questioned her despite the fact that she asked for a lawyer. So the bottom line, Judge, is it's a defensible case. She's not a flight risk, and recognizing the seriousness of the charges, I won't ask for personal recognizance, but I would assert to the court, this case does not justify more than a $5,000 cash bail.
Thank you. My guess is you have no objection to the proposed conditions.
Well, the only condition that I would ask to be heard on, Your Honor, is this condition that she not drive. The police and the district attorney's office and the registry of motor vehicles have options to address that issue if they believe that she's an unsafe driver. And I would ask the court not to get involved with that issue.
Thank you. All right, with regard to the conditions, she is ordered not to drive unless licensed or permitted by the Massachusetts Registry of Motor Vehicles. And I appreciate your argument, Mr. Yannetti, but due to the nature and the circumstances of the offenses charged, specifically 1 and 3, and the potential penalty, I know what your letter says, you're the lawyer, but she has plenty of reason to flee, given the potential penalty. I'm opposing the $50,000 cash.
There's a motion filed.
Yes, on the motion, I have Mr. Lally, a motion for preservation of evidence. Have you had a chance to review it?
I have, yes, Your Honor.
Do you have any objection to it?
I do not, Your Honor.
All right, thank you. I'll allow that.
Can I have a date, please?
And just to be clear for the record, with regard to that motion being allowed, Judge, I would ask that it be effective with the court's signature with regard to previous reports that have been filed and anything that's been gathered, and certainly going forward. There should be no destruction of notes going forward in this investigation.
Well, it speaks for itself.
Yes.
It's a preservation of evidence. I just signed it. It's 10:22 a.m. on February 2nd. That's when it's effective.
Thank you very much, Ron. In terms of a next date, can I have March 1st, Judge?
Sure. Mr. Lally, that work for you? If not, we'll go to another day.
If possible, yeah. If possible, the 3rd or the 4th, if that's.
Well, I mean, she is entitled to be brought back within 30 days.
Sure.
I mean,
But
I can do-
Mr. Lally, if I may, Mr. Lally, you can have a 9 o'clock, 11 o'clock, or 2 o'clock call.
then thank you. 11 o'clock on the 1st is fine.
All right, that work, Mr.
That
Yannetti?
works.
Thank you.
Mr. Duffy, 22 CR 66, court is setting bail in the amount of $50,000 cash to ensure your presence back here March 1st for a probable cause hearing. You have a right to petition the Superior Court for a review of that bail. Conditions of this case are that you stay away and have no contact with the victim's family, stay away from the victim's residence, and do not drive a motor vehicle unless permitted to by the Registry of Motor Vehicles. You'll need to sign those conditions before you're transported today.
Thank you, Ron.
Thank you.
Thank you, Your Honor. Thank you, Madam Clerk.
Okay.
All right.
All right.
What stands in recess? Gonna ask the clerk.
All right, so there you had it. That was Miss Reed's first appearance in court back February 2nd. She would then wind up going back to court, March 1st. But let's talk about, wow. What's with these 3-point turns, guys? We got 3-point turns in every damn PCA, I swear. So what's interesting to me is the hellos. Okay. Is the hellos by this woman, Jennifer McCabe, okay? Because that would be indicating like you're acting like he didn't come in, he didn't get there, okay? And you're doing this at 12:31, 12:40, 12:45, like you're acting like, he never arrived, he never got there. Now, lo and behold, again, this is 2022. Now here we are, 2023, right here and now. All of this evidence has surfaced, which is the phone records. The phone records of this Jennifer McCabe. What is that? Dr. Latina. Ooh. I know you've been busy, so I want to say a special hello. Love you, lady. Good woman right there. So right there, it's whoo. Guys could have met him outside, or somebody could have met him outside and be like, oh, hey, come around back. I don't know how the house looks, so we'll go ahead and we'll check out the house and everything like that. But immediately this woman, you would think, because she's the one that was talking to him and texting him, giving him where this house is and all this stuff. So, um, you know, he gets dropped off there. She didn't stay. And she's making it immediately, or trying to make it immediately known that, hello, hello, like, where are you type of thing. Um, this would be very interesting to me when the phone records come out and the the health data that goes with your iPhones and stuff like that. The reason it's amazing to me is because your victim, he was walking up and down stairs, going up flights of stairs. And this house is a 3-story house with a basement. And so he would at least had to go up 3 stories at some point. Hey, buddy, what's up? Hold on one second. All right. Back at it over here. So for him to be able to go up and down stairs, you can't just be walking around outside like aimlessly, okay? Your phone will register, and this is something that I did in the Sheldon Jeter Jr. case and the Chris Watts case, to be honest. So your health data will record after you go up so many stairs, it calculates as like one set of stairs climbed, one flight of stairs. And for your victim, he calculated 3 sets of flight of stairs. So right there, that tells me that's not able to happen unless you're inside that home, which could be like you went downstairs in the basement, and then you came back up, grabbed a beer, maybe out of the kitchen, you're talking around, then you're back downstairs. I don't think maybe you went upstairs to use the bathroom, but you would have at least had to go up and down, which means you had to have somehow been in that house at some point, because where are you going to walk up these stairs? He has his phone on him. His phone was found underneath him. I got Pele in here, so, it's 24/7, 24/7 soccer in this house. Breathe it. We breathe it in here. So initially, something that would have been known is they took, obviously, the victim's phone. Jennifer turned over her phone, and they had the victim's phone. They had Jennifer's phone. And I believe they had Karen's phone. She was cooperating. She was a cooperating witness, right? She has something to hide. She's like, I dropped him off. I went to bed. Or at least I was at home. Then he's not answering. She called him 49 times that night. 49 times. To me, that's normal. Of somebody that's just like, okay, what the hell were you at? What are you doing? You know what I mean? Like, are you still there? When are you coming home? Karen is going to be a millionaire. Karen is going to be 1 millionaire. God, that cell phone just never stops. So I wanted to point that out. The other thing is that the DA, like, what would be the rush to arrest, Karen and start doing all this? Like, just gather all the evidence, do, if you're going to do a freaking frame job, cover up all this crap, right? You would think maybe you shouldn't do a rush job and maybe you would have had a chance here. But you guys, there had to be so many people involved in this, and there are, because otherwise it wouldn't. Like, who's your ME that's looking at this body and saying, "Yep, that's what I would say that a car hit him." The fuck, they should lose their job. Everybody here should lose their jobs. But why not just do an investigation? Like, I almost feel like there should be a law about that, by the way. We'll talk about that some other time. How could you possibly investigate something in a matter of an incident happens on January 29th and you're arresting somebody on February 2nd? Fuck out of here. How is that even possible? It's not. But at the end of the day, these police officers, when you celebrate dump, here, give me the phone. You have your victim's phone. You plug it in, you download it, all the shit comes out, and you would have seen, oh, holy shit, look at this. He's walking around with his phone at this time, going up and down stairs. Like, where the fuck do you think he's doing that at? I'm just curious. What are you going to say in court where he's doing that at? Oh, his phone was just, his phone had a glitch. Like, who's going to believe that? You guys want to talk about who's going to believe all this stuff in the Brian Kohlberger case? Your phone has a glitch. No, I mean, that's just not going to fly. So then if he was inside the home, that means that she couldn't have hit him. She could have hit him when she left and left him for dead. How is he? What is he, Jesus? I don't know. I don't understand. No, he went in that home. He's going up and down the stairs. And that's just the start of it. But you would have got the Celebrite in front of your face. You would have seen that. Your analyst, you would have looked at this and you'd been like, wait a second. And let's say that you didn't have it then. You have it now, and you had it just a little bit afterwards, and you still have her arrested, still going forward with this. So I'm over here like, what's this motive? Like, what could have truly happened in that house that one would be like, how about this? You want to get away with something? Don't blame her. Okay. Blame the fact that he was drunk and he just passed out. And you have no idea what the hell the guy did. He walked out of the house. We assume that he went with her. Okay. But going and trying to frame somebody, like, why not just leave this as an unsolved homicide? That's my question in the Dr. Moore, Dr. Drake case too. Like, why? You want to cover up what you did, but doing it by framing somebody else, that leads to you're not going to get away with it, in my opinion. But if you just, I don't know, treat it and just don't ever solve it, you know what I'm saying? Like, I just think your odds of being able to get away with something are going to be a lot higher, you would think. But you must have pretty brass balls to think that you're that protected, So that's my issue with the prosecution, with the state, with the DA, is that as more information started coming out, it was enough to say, like, listen, kind of like in the Barry Morphew case, like, we're going to dismiss the charges, because if you ever want to charge her, come back, you know what I mean? Like, just so dismiss it. But that's not what's happening, guys. In fact, they're like double, triple, quadrupling down on this. And that's what makes it so sick, in my opinion. Now, my question always was, the past 3 nights, I said, what if she would have went into that home? When did they know that it was just going to be him? If he's lured to the house, was it known actually at the waterfront when they were all talking that, because she's like, well, I want to go, I'm going to go home, but I'll take you there. You know what I mean? Like, how would things have played out if she actually would have went in that house? What's going on with that then? Like, how would they have known and been so sure that, okay, it was only going to be him? Because people have talked about that it was he was lured, John O'Keefe was lured to this house that night. Well, what if she would have went inside too? How do they know that she wouldn't have? And then I started thinking the only way, in my opinion, that's possible is if there was conversation at the waterfront, about that it was only going to be him. So again, red flags right away. This Jennifer McCabe, 12:31, hello, 12:40, 12:45, hello, hello, hello. That immediately tells me that the plan was already in place because he was already in that house, unless she's like seriously like looking for him. But I don't think that you would say hello. I think that you would say things like, hey, where'd you go? Hey, where'd you go? Like because there was like, I don't know, 10, 15 people in this house. They were having like a legit bash with like an 18-year-old. Like, who has an 18-year-old at their cop party? Oh, wait, cops. It was a mix of like, older parents. I think it's cool to like provide alcohol for your minors with cop wives and cops and friends of cops. And it's just, yeah, it is what it is. But those hello, 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 12:31, 12:40, 12:45, that to me that screams setup right there. Because he's there, he's in the house. He's clearly walking up and down steps, So this Jennifer McCabe is a character, in my opinion. She will sell, in my opinion, her soul to the devil. She will. I know this turtle boy, he got a camera in on her and was like, you're wearing a pin, and meanwhile you're part of like, the people that did this to him, and you have no problem doing that. And she's over here having fundraisers and being at the courthouse for John, but meanwhile she did all this shit. Like, that's a cold bitch right there. Like, keep her away from your pets, keep her away from your family. Fucking sick, man. Those text messages. Oh, and by the way, they were trying to get. So I'll continue to play a couple more of these, because I want to kind of keep you guys that haven't seen the case, haven't heard the case. That was her first court appearance. What I played earlier was the intro to it, to kind of like, hey, that's like a recap of everything to where they are to date. I wanted us to go back, so I played her first court appearance. Then the next episode I will do is the March 1st, when they're back in the courtroom within the 30 days. Those are her rights. So I'll play that on episode 3 that I do. And I'm just going to continue to break down and put a timeline together. And I will share in the community posts other things that you can catch up and watch this. But the community has rallied around this woman. Take a look. Take a look at the rally around this woman. And I fucking love it. I love it. I love it. I love it. So I posted on my page and here.
So this hour, we're bringing you Wednesday's pre-trial hearing for Karen Reed. This is quite a case to watch in Boston. If you haven't heard about it, fear not. We're going to tell you everything you need to know on this show right now. So she's accused of murdering her boyfriend, John O'Keefe, who was a Boston police officer. They were at a party. There was a lot of drinking going on, a lot of police at this party. It was a very snowy night, and she's said to have hit him with her car and killed him. That's how the Boston police who investigated this says that's what happened. But her defense team says, oh no, it's not even close. They say that there were people at that home who attacked him, that he was attacked by a dog at that home and left for dead out in the snow. And they're saying that the prosecutors aren't turning over evidence that's important to their case. So here's a little more from the defense team. That's Karen Reed sitting there with one of her lawyers. Let's listen to more of
Kevin
the
Spacey's
arguments.
attorney.
These guys are good. They're really aggressive.
Good afternoon, Your Honor. May it please the court. We are, as indicated in our papers, we are seeking summonses, and this is dealing with the animal control issue, that Rule 17 motion. We're seeking summonses directed at two entities, the Canton Animal Control and the Canton Town Clerk, both. We believe they both have records. We know they both have records. These are records that we need, the defense needs, to shine a light on Karen Reed's innocence. These are records that are central to our theory of the case, and these are records that we have no other option to get but through a summons. They've indicated to us they have the records, but they need a court order. They need some sort of a summons. Your Honor, in furtherance of this motion, I want to talk for a quick second about a couple of undisputed facts. Undisputed fact number one, on January 29th, 2022, Officer John O'Keefe was found dead in the yard of Brian Albert at his house at 34 Fairview in Canton. That is undisputed fact, where he was found dead and what the circumstances were surrounding that death are why we're here now. Second undisputed fact, when John O'Keefe was found, he had this set of wounds on his right arm. The medical examiner indicated that these wounds were concomitant with his death in terms of the temporal, the time that he died. These were wounds that he suffered at or near the time that he died. And the Commonwealth looks at these wounds and says, there's nothing to see here. Why are we looking at this? This is, you're following a red herring, basically. This is just a road rash. This means nothing. It has no impact on our case one way or the other. This is, according to the Commonwealth, simply a set of injuries that John O'Keefe suffered at the hands of being struck by a moving vehicle. Well, first, I would ask the common sense question, does this look like a road rash? I mean, the court's got years, decades of experience, life experience and legal experience. Of course, this doesn't look like a road rash. It's not a road rash that any of us have ever seen. Or does it look more like claw marks and bite marks from an animal, which is exactly what they are? Second, if it was a road rash, where's the rest of the road rash? John O'Keefe had one set of injuries like this.
Just dragging him by the arm.
Deep puncture wounds on his arm, on his right arm only, from mid biceps to mid forearm and no other place. For instance, mid biceps and mid forearm that you might put in front of your face or your body if a large animal was attacking you.
A defensive wound.
Resulting in these wounds. Why are the wounds confined just to his right arm? What about all the other pointy bits of a human body? If someone is rolled under a car or rolled in gravel because of the car, what about the shoulders? What about the knees? What about the ankles? What about the elbows? None of that exists. These are the only wounds that are confined to his right arm, and they're deep scratch wounds, puncture wounds that are indicative of claw marks and bite marks from a large animal. And third, what about the Commonwealth's own expert? She has to have opined about this, correct? She has to have said during the grand jury, I mean, this was a full-throated investigation surrounding the potential murder of a police officer. What did the Commonwealth's own expert say? First of all, she was never asked by the Commonwealth during the course of the grand jury about the injuries. It took a grand juror actually asking the question of the witness, and she said, no, I cannot say that as a road rash. There's certainly not enough evidence to suggest that these wounds are consistent with a road rash. Well, she had to have at least talked about the fact that it was an animal, right? She had to. The Commonwealth had to have asked that question. She actually said nothing about whether or not that's consistent with an animal, because the Commonwealth very particularly did not ever pose that question. But we did. We hired one of the preeminent medical examiners in the country, a doctor by the name of Frank Sheridan, and he wasn't some deputy medical examiner. Dr. Frank Sheridan was the medical examiner for San Bernardino County in California, with more than 12,000 autopsies under his belt, the supervising medical examiner for one of the largest counties in California, and he concluded to a scientific certainty that these wounds are from an animal attack. Period. Full stop. So, what do we know about animals and the Alberts? Which is exactly where Officer John O'Keefe was found dead. In February of 2017, we know that the Alberts had a dog. There's a photograph of Brian Albert with the dog, Chloe, in the foreground. By 2019, the Albert family had registered ownership of that German Shepherd. Moving on to 2022, in January of 2022, specifically January 29th, John O'Keefe suffers these animal puncture wounds, these animal scratches, these animal bite marks that are heretofore and up to this date, today, completely unexplained by the Commonwealth. By May of 2022, Karen Reed's defense team starts asking questions about this animal, about these injuries, about the dog, about what dog existed at the Alberts house. Where is the dog? We started inquiring pretty significantly. That same month, amazingly, the Alberts informed the Canton Animal Control that the dog was remarkably and mysteriously rehomed. The dog was gotten rid of. And to date, the Commonwealth has yet, as my colleague just mentioned, has yet to release the tissue samples to us for DNA testing to determine if there's evidence in these wounds of a canine attack, which we believe there will be. During that grand jury testimony, Brian Albert admitted to three things. Number one, he admitted that he owned a large German Shepherd. His words, not mine. A large German Shepherd. Number two, he admitted that the dog was at his home on the night John O'Keefe, early morning hours, John O'Keefe was killed on January 29th, 2022. And the dog, according to his own testimony, was inside the house and never in the front yard, which is where John O'Keefe's body was ultimately found. And the third thing that he admitted was that the dog was, quote, not great with strangers, end quote. That's a dog owner's euphemism for the dog bites, the dog attacks. The dog is mean or can be mean. So why wouldn't the Commonwealth ask about these injuries? Why wouldn't the Commonwealth inquire, as we have been inquiring, about the nature of these injuries and their significance in terms of John O'Keefe's death? It's because they know that the answer completely obliterates their case. Their theory of homicide would fold if they got the true answers to these questions. The answer exculpates Karen Reed, and the answer inculpates Brian Albert. That's because if that dog was inside the house that night, not on the front lawn, not in the front yard, but inside the house, and these injuries were suffered or sustained at the time John O'Keefe was killed, then that means John O'Keefe was inside the house when he was killed. And it also means that his body was moved. That's consistent with the facts that we also know to be true, which is not one person that was in that house and ultimately exited that house from that party that night. Not one saw John O'Keefe's body laying in the cold in the front yard. And that's because he wasn't there yet. Multiple people walked out of the house, multiple people who would have no other reason, would have no reason to lie about that. A 200-pound man, 6'2", lying in the front yard on a light dusting of snow in dark clothing. Not one person saw him.
Boy, oh boy, are you persuaded? Gotta tell you, this is intriguing stuff the defense is putting forth here. Is there any truth to it? Tweet us. Let us know what you think about this case. At Court TV is our network handle. At Julie Court TV is mine.
All right, guys, there you have it. We're gonna wind up here. Right here is the end of and closure of episode 2. I'm telling you guys, buckle up. You guys are in for a wild, wild ride, but I am on it right now. We are trying to locate this canine. We are trying to find this dog. That is what we are working on over here at Truth and Transparency. We will see you next time. Again, later on this evening, I will have a recap of the Idaho 4 interview that I did last night. So questions, I will be dropping the link for people that had questions. Not sure if I can answer them, but a discussion about that interview and the things that were said from Chuck Kelsey. Again, thank you guys for being here. On your way out, make yourself known. Thumbs it up, thumbs it down. You have an opinion, make it known. Also, Turtle Boy did a lot of great work on this case. Go check out his page. A lot of support for Karen Reed. I think that Karen Reed is 100% innocent, and this is wild. So until next time, be kind. Be kind.